My focus today will be essentially on this subject called scandalizing the judiciary, and I'll touch on a bit on what is covered by Ms. Young. Okay, first line. This is where I'm coming from. This is what I'm covering. Scandalizing the court, and the bill says that any person who scandalizes the court by publishing or by any act, then you do these things, impute improper motives, then you commit contempt of court. This is the scope of my, principally this is what I'll speak about. All right, now, then it says that, this bill also says that intention is irrelevant. All right, you may say that you have no intention to say wicked things about the judiciary. Too bad. You are in for the hot soup if you do say wicked things about the judiciary. Intention is not relevant. All right? Now, the purpose of the doctrine, right? It is not to shield judges from publication of fair criticisms. Okay? You can criticize judges. It is not to protect the dignity of the judges, but it is to protect the integrity of the administration of justice by the court, who has a central role in under the rule of law. Scandalizing the court may, depending on facts and surrounding context, embrace conduct like or words that undermine confidence in the public confidence in the integrity, propriety, impartiality of the court, and therefore of the authority of the court as a whole. These are lawyers that usually guilty of verbiage lah. So I will reduce it later on into specific instances where to explain what all these words means. I think there's only 1, 2, 3 full stops in the whole verbiage. Okay. Good example. A good example is this. Alex Lau kena fine 8K. Right? What he said was that it was a strange calendaring of the constitutional challenge of the 377A one. This A is the one, the anti-sodomy law, right? Alex was complaining, he was writing in his yawning break article, he said, how come the Court of Appeal, when is the Court of Appeal going to hear the case? Because, Justice Peter Low had heard my, one case which I defended, that was Lim Ming Suan. Can you hear me without the mic? No. Okay, fine. So I defended Kenneth and Gary, a gay couple, and we challenged the law. We wanted the law to be declared as discrimination against the equality rule in our constitution. The judgment came out, but then there was another judgment involving another person who challenged the law, and that is Tan Eng Hong. And there was a gap, and we were waiting for and then it came out, and then in the meantime, the court fixed the CA appeal for my case. So Alex Au hypothesized that, the reason why there's this delay was that the CJ wanted to hear the appeal, and the CJ can only hear the appeal of the case of Kenneth and Gary. And the CJ Menon cannot hear the case in the appeal if Tan Eng Hong's case went up, because CJ was the AG when Tan Eng Hong was prosecuted. So he put up this theory, and then he said because of that there was some strange going on in the judiciary, in the calendaring, and therefore he was charged for contempt, and there was allegation, and the court said that he insinuated that CJ wanted to hear the case, and then what the court did was not quite right, and therefore he got fined 8K. Okay, that's one example. Another example. John Tan and two others, they went to court with a t-shirt depicting kangaroos. Okay. So again, the court said, no, this is not right. You actually scandalize the judiciary. How can you say our court, are kangaroo courts? So this is another example. And Mr. Gopalan Raya, okay? Yeah. If you read his, by the way, just a digression, if you read his blog site, Singapore Dissident, you will notice that he mentioned that Peter Low is the hatchet man of Lee Kuan Yew. Don't believe him. I checked it, I think it's still there yesterday. Because I represented Dow Jones when Dow Jones was sued for defamation by Lee Kuan Yew and PM. I don't know why he wrote that to the on the thing. Anyway, he said wicked things about Justice Belinda Ang. You see that? This is really wicked, huh? And then Justice continued to say he attacked the Justice Belinda Ang, and therefore this is wicked, and he was charged. That's clear case of contempt. And this is, he said also the same thing about wicked things about Julius Prakash. Yeah, you are? Has not totally shamelessly and with open eyes done injustice to the three defendants. But he said this time he said it in the safety of the US, and he was not charged in court as such, but CJ appointed me to take out action to disbar him, and he was disbarred in absentia as a lawyer, but not as a defendant in a contempt case. So these are the three examples I think I have. I don't know whether I have got an example. Okay, then I'll move on to something else. Fair criticism is allowed. Okay, I mean, actually, we lawyers, we criticize judges all the time. You know, in our appeals, you will list a whole long list, all the sins of omission and commissions of the judges. You know, the judges fail to take into consideration this factor or that factor, or the judges did something wrong. We do it all the time. So, fair criticism, even outside the courts, extra judicial criticisms are allowed, because in most Commonwealth countries, you are allowed to criticize, make robust criticisms, and even you can even express trenchant views about certain decisions of the courts, and they should not be ruled as contempt. Yi Xiong quoted one famous judgment where the Privy Council said that justice is not a cloistered virtue. That means the decisions of the court should be up for scrutiny openly. Now, here is a statement from our Apex Court, Judge of Appeal Andrew Pang. See, there's always this tension between the law of contempt and free speech. There's always by the law of the Constitution, which is the first law of our country, and every other law is subordinated to our Constitution. The Constitution says you have the freedom of speech expression. That's the law. However, there is an exception. There's a restriction, an exception to the rule. And that restriction is that it's subject to law of defamation and, amongst other things, contempt. Okay? So judges have said that, look, there's a balance. Balance. You got to, on the one hand, you want to have free speech. That's okay. But except on the other hand, the free speech is not absolute. It can be restricted lawfully by law of defamation and by law of contempt. And when you say all those wicked things about judges, you actually cross the line, and therefore you can be charged with contempt. Here is our former Chief Justice. Doctrine of contempt should not be used to stifle fair, reasonable criticism of the work of the judiciary and also judicial decisions. I mean, that is good sense, and that should be the rule in a democratic country. Okay? The right to criticize, okay, is part of the freedom of speech and expression citizen enjoys in a democracy. Its purpose is to encourage and ensure judges are independent in their decision making, and fair and objective criticisms will instill accountability and greater discipline in decision making. If no one is allowed to judge judges, there will be lawless courts and irresponsible judging. I think this really makes good sense. Next. And here is a case where Alexa, this time he was acquitted. He made, you know, I mentioned he was just now, he was convicted of and sentenced for fine 8K, right? For that blog post where you complain about strange things happening about the rostering of the judges to hear the 377A cases. In this case, he made this remark. Okay? When he came to see me at first, I thought, oh dear, surely kena done for lah. How am I going to see a judge and say, you know, my client said my confidence in the judiciary? But within the context, within the facts of the case, okay, within the context and within the facts of the case, it was all right. Because actually what he did was he was complaining that about there's this suit where Robinson's, you know, kicked out somebody because he's gay. And he said, you know, that's got nothing to do with performance. The fellow was quite a good, I think, supervisor. You know, and the judge was wrong in sacking that fellow. I think I can't remember his name. Lawrence Reed, that's right, yeah. So he was criticizing the judgment. So at the end of the day, the judge said, you know, Justice Belinda said, no, there's nothing, there's no improper motive, you know. He was entitled to criticize the judgment. He's entitled to say that, sorry, he did not attack, he was not actually attacking the judge who dealt with the other decision. So it's all right for you to say my confidence in the decision, although it sounds quite wicked lah. I told you earlier, right, there's a tension between freedom of speech and the restriction of freedom of speech. In UK, in the old act, it says this, you know, you can, so long you can, in good faith, comment on matters of general interest, and if the risk of contempt is, if the risk of impediment or prejudice is not so incidental, then a person should not be charged for contempt, because I think in that jurisdiction, people put a higher premium on constitutional provisions. Even UK hasn't got, strictly speaking, a written constitution. Next, I go on to the proceedings. Like proceedings in chambers, and sorry, this is in camera. Proceedings in camera, you are not guilty, right? If you publish in good faith, fair, accurate report, okay, before any court sitting in chambers or in camera, and then unless the exceptions where in certain provisions, certain law, there are certain laws which says that you cannot publish certain things. Like for example, for family cases, you're not supposed to name children and name family members. Okay, there are some specific laws on that. Or there are other reasons where, you know, for matter of public policy, or where the matters discussed were national security matters, then you shouldn't publish. Open court proceedings, the rule is that open court proceedings in UK and in Singapore, you should have good you should be examined if there's fair and accurate report. Okay. Likewise, orders of court so long as they're fair. If you put documents in court, if you file, like lawyers when we file documents in court, it is not, in good faith, it is not contempt of court. This is new. I'm not so sure what it is designed to achieve. For us lawyers, and I'll come to the next point, for us lawyers, we always file applications by, all sorts of applications by clients, and if it is bad, right, it is bad, the court will just say, look, it is your application no merit, dismiss. Or your application is frivolous, vexatious, and abuse of the process of the court. That's it. At the most, you cannot pay costs. Right? That's all. No contempt proceedings. Now, there's the next provision is this disqualifying a judge. It says here that you're not guilty if you try and disqualify a judge and you have good faith and you deal in good faith. Okay, that's not wrong. Again, existing law, existing practice, if we try to disqualify judges sometimes because for various reasons, conflict or what. So we do that. And again, under existing law, if your application is without merit, frivolous, vexatious, abuse of process of court, at the most you cannot pay personal costs. That's all. No contempt. Yeah, sorry. I'll give an example. An example, a high-profile example of an attempt to disqualify a judge was when this group of gentlemen, no need to mention their names, plus 6 MPs sue my client for contempt of court. Okay. He took an application to disqualify the judge in respect of this lawsuit. Okay. And he said that the learned judge, the late Justice Lai, he made all these allegations. He said that the judge, these are allegations, the judge worked in Lee & law firm many years, legal assistant, then partner, then became High Court judge. And then Lee advised LKY and his family members on many matters in the past. And as a member of Lee, Judge had close working relationship with LKY and family members. Then Judge acted in a variety of matters involving LKY and his family members. Then it was widely known that Judge was a close friend of Lee family. 7, Judge and wife bought an apartment at Nasim J on the same day as as LKY and BG Lee. And then Judge got a discount. I mean, he was not the only one who got a discount. And then the judge also issued unusual orders against him and his wife. So he took out this application to disqualify. Now, these allegations, all these allegations were, of course, hotly contested. Because LKY put in an affidavit to say, how dare you say this sort of things, it's not true, it's not true. And then Go Chok Tong also filed an affidavit. And then, next slide, please. You know, I come from that generation, not very good with computer. Yes, thank you, Priscilla. So the judge said, look, no evidence to disqualify, no evidence to disqualify the judge, no apparent bias, and Tang was guilty of abuse of the process of the court. Okay, but today, same slide. Today, under the new section 17.2, I'm not so sure. It may well be that he will be liable to a charge of contempt. The consequence for him was only pay costs, and because he was a lawyer, referred to Law Society for disciplinary action. Plus, his lawyer, that's what happened to him. Now, these are the sentences, punishment which the court can induct: fine not exceeding 100K, jail 3 years, That's for matters here. And matters from here, state court, family court, and youth court, which goes up to the high court has powers, has these powers, fine no more than 20K, jail 12 months, both. Then in any other court, same as 2. Okay? Okay, there's this one part, as I move on to another important part of the bill, which is important now. It says that a statement made by a person on behalf of the government, doesn't say who, whether a clerk or a permanent secretary, about the subject matter of, sorry, wrong spelling, of an issue in court proceeding that is pending is not contempt under subject if the government believes that such statement is necessary in the public interest. Okay? So, sorry. So, and the bill gives an illustration. Statement made by a person on behalf of the government, okay, don't know who this person is, factually describing the events and circumstances relating to and leading up to the death of a person, such as acts of public officials when a coroner's inquiry into the person's death is meaning something like somebody like Benjamin Lee, which the government believes is necessary to address inaccurate or incorrect public allegations, is not contempt. Okay. Example, okay, Law Society president. He said that, he gave us, this is a law gazette, it is for Law Society members. Okay, circulated, I think, about 5,000 lawyers. It was lifted, it was published, and this is what he said. Why this 14-year-old boy jumped down? Could this death have been prevented? We can never know for certain, but that shouldn't stop us from pursuing a deeper inquiry to what happened to Benjamin Lim that day. Police could have considered a less intimidating way of approaching the investigation. If Benjamin's death was avoidable with a better system, then is one death too. The context is this, as lawyers, as criminal lawyers, we always have this problem. We have been having this problem since I don't want to betray my age. But it's been a long time now. No access to lawyer. When you see your lawyer, okay, you know that the lawyer will know that the client has more or less contest. So you're not, if you can't even go there and tell the client, hey, you don't have to incriminate yourself, because there's something in the law which says that you should answer truthfully what the police ask you, but you need not incriminate yourself. We cannot advise the client, hey, after you do the statement, the statement must be read over to you, and then you confirm it's correct, and then you sign. The lawyer can't be there. Okay? And then you can't be there to say, hey, these police officers cannot threaten you, cannot offer you inducement or promise you anything. You can't do all this. No advice. So that's the backdrop now. And in this case, 14-year-old boy. But then a person of the government, is it? Made this statement. So the matter, and I pause here because I want to raise a matter which my good friend Mr. Wem raised just now. The bill says contempt attaches from the inception of police investigations. When the police arrest you, warrant arrest is issued, or you receive a notice that you're under investigation, you've got to go to court, that's when contempt attaches. The rule attaches. It ends after the appeal case. In between, what do you do? Are you supposed to shut up? Let's see Shenny's speech. Is President of the Law Society supposed to shut up? Because there was a coroner's inquiry. That's the problem. is what we see in the bill. Okay, not only if Lindley is doing the documentary today, then there is a problem because it's not clear whether she's supposed to shut up and forever remain silent. No, wait until the appeal hearing is concluded. That's the position. Now, if that is so, then it's very bad. I mean, it's not good for us. I mean, there should be open discussion about matters of public interest. And the death of a 14-year-old boy is a matter of public interest. Why did he die soon after he leaves the police station? It's an example. But I think the illustration I read to you just now, if a person of, what's the term? That's right, thank you. Yeah. A person on behalf of the government. So if this person can speak, but other people cannot speak, it's funny, right? Okay. Then the other thing is also, again, a person on behalf of the government who can speak about a riot, but looks like other people not authorized to speak. Okay? And you see this what happens in the past. This is when there was a public comment on 3 Singaporean men charged with allegedly committing some offense during the Thaipusam, right? So AGC shoot out a press release. Earlier ones, Priscilla. That's right, thank you. AGC says, as criminal proceedings are currently before the court, we would like to remind public that statements made may be sub judice contempt if the statements are calculated to affect. Okay? And then AGC says AGC takes a serious view of that statements made which are calculated to interfere with the integrity of the admin of justice and anybody for information itself. So again, there's a clampdown of free speech. Next, 3778 again. You know that when the challenge of in the court, AGC issued this press release and everybody had to shut up until the end of the criminal appeal case. Move on. Okay. And here you see my friend, Mr. Ravi, he complained that whilst he was defending this gentleman in death row, right, and then the minister gave this statement. The appellant who was sentenced to death for trafficking in so and so is young. But if we say we let go, what's the signal we are sending? We are sending a signal to all drug parents out there. Just make sure you choose a victim who's young or a mother of a young child and use them as people to carry drugs. Mr. Ravi complained that this statement came out 4 days before the decision of the Court of Appeal. Mr. Ravi issued a press statement. So I think, next. Okay. This is another case. This is between charge and trial. This is one of my famous clients. He sex for great case, right? He came up to court and on the day at the steps here of the court, he said, "Look, the charges against me are very serious. At stake is my liberty, etc., etc." And he said, "I will fight until the end." Is he supposed to shut up under the new bill? Next one. This is where he went. I went to court to get him some grades of the student because he was charged for exchanging grades for sex, right? So I went to court to say, let me see all the grades of all his students to find out whether true or not that this particular girl, a top student with whom he was supposed to have, with whom he had sex, whether she got favorable grades. And he made this statement. Right? He wanted the law faculty to produce his the examination script of all students, followed by CPIB. He wanted the medical records from Alexandra about his hospitalization, because after he was interrogated by CPIB, he had to be sent to Alexandra Hospital. He wanted the prosecutor to make clear what were the charges against him. Now, coming from the perspective of a defense counsel, to my clients, of freedom of speech is important. It's very important, because once you are an accused person, right? The accused person, this is not a very good phrase, lah. But the rules of the game is like that. The rule of the game is against the accused person, because in a criminal case, the moment you are arrested, right? The moment you are arrested, there's a likelihood that there will be publicity, and that sort of media publicity, like the professor's case, it pursued him from the time he stepped into the court, and then until the court case starts, and then until the end of the prosecution's case, and that period can be a long time. And during this long period, the accused person's character is blemished. You know, the entire world knows how bad the accused person is, and it's very important to the accused person, because if he goes, if he goes to the lift, neighbors say, you're the one, huh? And then it affects his family, and then it affects his children, and sometimes children say things they don't intend. They don't have bad intention, but they say things which hurt other children. Their children, the children of the accused will be going to school, and any other fellow student will say, "Hey, that's your dad, right? I saw on television." So it has impact on the accused person. That's why it's important for defense counsel and for accused person to be able to stand up and say, "Look, this charge, I'm not guilty. I'm going to fight. I will die fight. Even if you say I'm guilty, I'm not guilty." That kind of, he's entitled to make that speech. I don't think he should be shut up purely because of the tax, because he has been charged or informed that a warrant of arrest has been issued against him. Okay. Punishment. Just I covered punishment, but this table just shows you the type of punishment which have been issued, which have been meted out up to today, lah. Okay. I mentioned to you that the punishment in the mentioned in the bill is 100K, and imprisonment of 3 years. Yes. But you see that so far, Chief Justice Chan Sek-Kyong said that so far the costs have been quite restrained, and the fines are quite decent. Okay, even LXR was fined 8K. That's less than 10% of the 100K mentioned in the bill. And Alan Shadrach, his case was very bad. I think altogether he had 14 statements, contemptuous statements, and he was the Court of Appeal said this was a very bad case. It's one of the worst cases of contempt. But his fine was 20K, 6 weeks. So I now move on to thank you.